Okay, good morning, everyone. My name is Judge Tamika West. I will be presiding over your first appearance hearing for this morning. We are streaming live via YouTube. Although we are virtual, please conduct yourself as if you're in person in court. If each individual defendant will raise their right hand, and I'll need to see everyone's hand, and I need your full attention. Do you swear and affirm that the information that you give to this court today, as well as the information that you provided on your court-appointed counsel form, is true and accurate to the best of your knowledge?
Yes.
Okay, thank you. You can put your hand down. Thank you. I will make some opening remarks before beginning your first appearance hearing this morning. So please pay close attention with respect to your rights. First, we are not here to try your case today or to take a plea. The purpose of today's hearing is to inform you of the charges against you, advise you of certain rights, and set bail on those offenses for which the court is authorized to set bail. I'm required to schedule a preliminary hearing for you today and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you choose to give up this right, anything you say during these proceedings may be used against you if your case goes to trial. Doing this and all other proceedings, you have the right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt. You have the right to indictment by the grand jury for most felonies or by accusation for misdemeanors. You have the right to a speedy and public trial by jury. You also have the right to see, hear, and cross-examine all witnesses who are called to testify against you. You have the right to compel the attendance of witnesses in your own behalf by subpoena. You also have the right to testify and offer other evidence in your own defense, should you choose to do so. But should you choose not to do so, no presumption of your guilt may be raised. You have the right to have an attorney assist you during these proceedings and all other court proceedings. Some of you will be allowed to post unrestricted bonds for your release from jail pending prosecution of your case, which may be by cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond in cash together with any applicable mandated fees to the sheriff's office, who will hold it until your final court date, at which time the cash bond will be returned to the person who posted it on your behalf. If you use a commercial bonding company approved by the sheriff, someone will have to post or pay the company up to 15% of the total bond amount as their fee for their service. This fee will not be returned. Someone may post bond using their property if they have net equity in the property in an amount equal to 3 times the amount of the bond. Some of you will have special conditions on your bond order that prohibit you from contacting certain people or going to or around certain places. These special conditions will be provided on your bond order. You will also be prohibited from contacting or having any contact with the alleged victim while you're in jail and out on bond. Should you violate the court's order, your bond will be revoked and you will not be entitled to another bond while awaiting trial. An additional charge of aggravated stalking, influencing witnesses, or other charges as the law may provide could be brought against you, for which you could be sentenced up to 10 years in prison and up to $20,000 in fines. For family members who will assist you in posting bond, they will be provided with your bond information after I've concluded the first appearance calendar for this morning. If a family member is an alleged victim on the warrant and there's a special condition that you're to have no contact with this family member, he or she will not be allowed to post bond on your behalf. Some of you are charged with offenses for which this court is simply not authorized by law to set bail. In this event, a bond hearing will be scheduled before a superior court judge, and you will be informed of that date at your first appearance hearing today. If you are currently on active probation, this court is not authorized to set bond. Your bond can be reconsidered after a probation officer has had the opportunity to determine if they wish to file a warrant revoking your probation, and this is usually during your preliminary hearing. The purpose of a preliminary hearing is to determine if there is enough evidence or probable cause to justify keeping you detained in jail until such time as your case goes to trial. For those of you charged with misdemeanors only, you will have the option of waiving your preliminary hearing. Waiving your preliminary hearing will not affect your right to post bond, your right to have an attorney represent you, or your right to have a jury trial. If you post bond, your preliminary hearing is automatically waived, and you will be mailed a notice as to when to appear in state court for your arraignment. If you cannot make bond, you may waive your preliminary hearing and be taken before a state court judge, at which time, if you plead guilty, you will be sentenced. If you plead not guilty, a trial will be scheduled on your behalf. If you choose to have a misdemeanor preliminary hearing, the hearing will be scheduled for November the 29th, 2022 at 8:30 a.m. via Zoom. For those of you charged with felony offenses, you will not have the option of waiving your preliminary hearing. Your preliminary hearing will be scheduled for November the 28th, 2022 at 8:30 a.m. via Zoom. That will conclude my opening remarks. At this time, I will take the first defendant for the female's deputy.
Your Honor, we have a fugitive inmate, female.
Okay. Let me do. Let's see here.
Or do you just want to go in order?
No, I'll usually do my extradition hearings last. So I'll do the female inmate extradition last.
Yes, ma'am.
So let's do that. Is that Francis' last? Is that Francis' last name?
Way, last name Way, Bria Way.
Way. Okay, let's see. Okay, I have her. So yes, I'll do her last. Okay, give me your full name for the record.
That's me, Marie Bentley.
Okay, Ms. Bentley, it's spelled Bentley. Is that correct?
Yes.
You've been charged with 1 count of criminal damage in the 2nd degree. Your bond amount is $3,000. Do you understand the charge as well as your bond amount?
Yes.
Can you make bond?
Yes.
If you can make bond, there will be a special condition included on your bond order. The first condition is you to have no contact with the alleged victim in the case, identified as Madison Moore. Do you recognize that name?
Yes.
You're to have no contact, which means you must stay away, absolutely, directly, indirectly, by email, by mail, by pager, by text message, by social media, by telephone. You cannot contact her through a third person. You must stay away from her home and her workplace. Do you understand that? I need a verbal yes.
I say yes.
Okay. Secondly, I schedule your preliminary hearing for November the 28th, 2022 at 8:30 a.m. because criminal damage, 2nd degree, is considered a felony. You understand that?
Yes.
Then lastly, I see that you did complete a request for court-appointed counsel. Based on your application, you would qualify for a court-appointed attorney. So I will approve your application. Do you have any questions?
No.
Okay, thank you. Can you give me your full name for the record?
My name is Ruth Brianna Daniels.
Okay, is you say Ruby Daniels, correct?
Yes, ma'am.
Okay. Ms. Daniels, you've been charged with 2 offenses. The first offense is identity fraud. Your bond amount is $4,000. The second offense is theft by deception. Your bond amount is $4,000. Therefore, your total bond is $8,000. Do you understand the charges as well as your bond amount?
Yes, ma'am.
Okay, can you make bond?
Yes, I can.
Secondly, I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. You understand that that's your next hearing date?
Yes, would I get a piece of paperwork?
It'll be on it's on your bond order.
Okay.
So it's
All right.
November the 28th. And then you did complete a request for a court-appointed attorney.
Uh-huh.
And based on your application, you would qualify, so I will approve the application. Any questions?
No.
Okay, thank you. Okay. Okay, please give me your full name.
Tiffany Dameron.
Okay, Ms. Dameron, you've been charged with 6 offenses. The first offense is violation of Georgia Controlled Substance Act. Your bond amount is $5,000. There's a second count of violation of Georgia Controlled Substance Act. Your bond amount is $5,000. The third offense is use or possession of drug-related items. Your bond amount is $1,500. The fourth offense, reckless driving. Your bond amount is $1,500. Fifth offense is red light violation. Your bond amount is $500. And then the last charge, destruction of a law enforcement officer. Your bond amount is $1,500. Therefore, your total bond is $15,000. Do you understand the charges as well as your bond amount?
Yes.
Okay, can you make bond?
I'm gonna try.
Okay. Secondly, I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. You understand that that's your next court date?
Yes.
And then let's see here. It does appear that you completed an application for court-appointed counsel. You do qualify. Therefore, I will approve your application. Any questions?
Ma'am.
You have any questions?
Ma'am.
Okay, thank you. Give me your full name.
Garcia.
Okay, Ms. Garcia. You've been charged with 3 offenses. The first offense is violation of Georgia Controlled Substance Act. Your bond amount is $5,000. The second charge, use or possession of drug-related items. Your bond amount is $1,500. The third offense, no tail lights. Your bond amount is $500. Therefore, your total bond is $7,000. Do you understand the charges as well as your bond amount? You say yes?
Yes, ma'am, I understand.
Can you make bond?
Yes, ma'am.
You say you'll try?
Yes, ma'am.
Okay. Secondly, I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. You understand that's your next court date?
Ma'am. Yes, ma'am.
And based on your application, are you currently unemployed? You didn't answer that question.
No, I am.
You are?
Yes, ma'am.
So based on your application, you would qualify for a court-appointed attorney, so I'll approve your application. Any questions?
Thank you.
Thank you. State your full name for me.
Dana D. Gibson.
Okay, Ms. Gibson, you've been charged with 5 charges. The first charge is battery physical contact. The second charge is aggravated assault with a deadly weapon. The third charge is criminal damage in the 2nd degree. The 4th charge is cruelty to children in the 1st degree. And the 5th charge is reckless conduct. Based on the nature of the charges as well as the circumstances, I am denying you bond today. Do you understand the charges as well as the no bond?
Yes.
I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. and then your bond hearing will be December 2nd, 2022 at 8:30 a.m. You understand those 2 different hearing dates?
Yes.
Lastly, it appears you did complete a request for court-appointed counsel. You will qualify, so I will approve your application. Do you have any questions?
No.
Okay, thank you.
No.
Okay, give me your full name.
Alexis Kiana Green.
Mrs. Green, you charged with 3 offenses. The first offense is theft by receiving stolen property. The second offense is driving on a suspended or revoked license. And the third offense is use or possession of drug-related items. Because you're currently on active probation, I'm not authorized to set bond for you today. Do you understand the charge as well as the no bond? Okay. I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. via Zoom. And then your bond hearing will be scheduled December 2nd, 2022 at 8:30 a.m. Do you understand those 2 different hearing dates? I see you did complete a request for court-appointed counsel. Based on your application, you will qualify for a court-appointed attorney. So therefore, I will appoint an attorney to represent you. Do you have any questions?
No, ma'am.
Okay, thank you. Okay, give me your full name. I didn't hear you.
Jukiria Deborah Lewis.
Ms. Lewis, you've been charged with 1 count of criminal damage in the 2nd degree. Your bond amount is $3,000. Do you understand the charge as well as your bond amount?
Yes.
Okay, can you make bond?
Yes.
I've scheduled your preliminary. If you can make bond, there will be a special condition included on your bond order.
Well, I don't know.
Let me finish. Let me finish. Let me finish. You will have a special condition included on your bond order. The first condition is you're to have no contact with an individual by the name of Madison Moore. That is the alleged victim in the case, which means you must stay away absolutely, directly, indirectly, by mail, by email, by pager, by text message, by social media, by telephone. You cannot contact her through a third person. You cannot go to her home or workplace. Do you understand that?
Yes.
Also, you cannot violate any laws while all on bond. Do you understand that?
Yes.
Secondly, your preliminary hearing is scheduled for November the 28th, 2022 at 8:30 a.m. via Zoom. You understand that's your next court date?
Yes.
Okay, and then did you complete a request for court-appointed counsel?
Yes, ma'am.
Okay, based on your application, you would qualify for a court-appointed attorney. Therefore, I will appoint an attorney to represent you. Do you have any questions? Okay, thank you. Okay, please give me your full name.
Bria Francesca Way.
Okay. I believe does that conclude the female deputies?
Yeah, they just took them all out.
Okay,
Yes, ma'am.
okay, thank you. Give me a minute to locate your paperwork, Ms. Way.
Yes, ma'am. She asked the job, yeah, everybody finished with me.
So, Ms. Way, again, my name is Judge Tamika West. This is your hearing. This hearing is what is called an extradition hearing. All the rights that I've advised everyone else of apply in your case, but your hearing is just a little bit different than the other first appearance hearing that have taken place today. First, you do not have charges pending against you here in Clayton County. You have been brought to the court today because you have charges pending against you in another state, and they're requesting that you return to that state to answer the charges against you, specifically the state of Florida. Are you in fact Bria Francesca Way, W-A-Y-E?
Yes, ma'am, I am.
Do you have an attorney representing you in this matter?
For the extradition?
Yes.
No, ma'am.
Now, you've been charged with a fugitive from justice. This hearing has been conducted pursuant to OCGA Title 17, Chapter 13. Now, as you've heard, it is alleged that the state of Florida is requesting that you return to the state for an outstanding warrant. You understand that?
Yes, ma'am.
You have a choice as to whether or not you wish to contest the extradition or waive the extradition and be returned to the other state without going through the formal extradition process. If you decide to contest the extradition, the court may commit you to the county jail for an initial period of 30 days. During that time, a warrant will be prepared under the governor's signature for your extradition to the other state. The court may consider allowing you to post bond, but the court is not required to allow you to post bond. As you're wanted by another jurisdiction, I'm not setting bond for you in your case at this time. You understand that?
Yes, ma'am.
If you do not wish to voluntarily return to the state of Florida, you may file what we call a writ of habeas corpus to contest the extradition. The writ of habeas corpus can only contest 4 things. The first is whether the extradition documents are in order on their face. Secondly, whether you are charged with a crime that actually exists in the demanding state of Florida. Thirdly, is whether you are the person named in the request for extradition. And fourth, whether you are in fact a fugitive from justice. You cannot contest the issue of your guilt or innocence in this state, the state of Georgia. You are entitled to the advice of counsel in contesting extradition or in deciding whether to waive extradition. If the state is unable to extradite you within 30 days, you may be committed to the county jail for an additional 60 days while awaiting your extradition. If the extradition is not complete in 90 days, then you will be released. If you decide to voluntarily waive extradition and return to the state of Florida will have up to 60 days to travel here to transport you back to the state of Florida. If they do not come to transport you back to the state of Florida for a period not to exceed 60 days, then you will be released. Do you have any questions regarding anything I just explained regarding your rights?
Just one question, ma'am. You said 60 days?
The 60 days, yes.
Yes, ma'am.
So if you waive, so if you contest it, you will be committed. So let me go over it again. So if you contest it, the state is, if the state was, if you contest it, then they will have up to 90 days to extradite you. Okay. If you voluntarily waive it, then, so if you voluntarily waive it, then the state of Florida will have up to 60 days to extradite you back to the state of Florida.
I'm gonna waive it. I'm gonna waive it.
Okay. If you're gonna waive it, then there are 6 waiver forms that you'll need to sign from the deputies. So you make sure you sign and not print your name, and then they'll return those waivers to me for me to sign. You understand that?
Yes, ma'am.
Do you have any questions regarding your rights?
No, ma'am, you've been very thorough. Thank you.
Thank you.
Emails, Your Honor.
I'm sorry, do you have the waivers form for Ms. Way?
Yes, ma'am.
Okay,
Excuse me, Your Honor.
yes,
One more question. You don't happen to see the warrants that I have in other states? You can only see this one, right? For Florida,
yes.
that's all you see?
I do have the warrant number on here. Let's see. Only thing I have is the warrant number.
It's just Florida, okay.
It says for fraud. It says for fraud, and then it's warrant number W765329188. That sounds, the charge of fraud, does that sound familiar?
Yes, ma'am. I know I have a warrant in Florida, but I was trying to see if there's any other warrants, like any of the other states.
Not on this. Only this is, it's the state of Florida that's demanding your return.
Okay, yes, ma'am. Thank you.
Okay, thank you. Okay, I believe we're ready for the first male inmate.
Yes, Your Honor. Hey, Fallon, bring him up. Bring him up. Come on, man. You need to get yourself with it. You can do you real quick to get you back. And then you're next after him. Jump into the back.
Okay, give me your full name, sir. I'm sorry, I didn't hear it. Deputy, what is his name? I didn't hear him.
What's your name, sir? His last name is Dodson.
Okay, we're taking him out of order.
He's 24, ma'am.
Okay. No problem. So you've been charged with 1 count of criminal trespass. Your bond amount is $1,500. Do you understand the charge as well as your bond amount? Can you make bond, sir?
I'm not sure.
Okay. If you can make bond, there will be a special condition included on your bond order. Specifically, you cannot return to the location, the incident location of Comfort Inn Suites, and it's located at 2192 Mount Zion Parkway. You understand that? You can't return to that location if you're out on bond.
Yes, ma'am.
I've scheduled your preliminary hearing for November the 29th, 2022 at 8:30 a.m. You understand that's your next hearing date?
Yes, ma'am.
And it looks like you refused to complete the court-appointed form. Do you not need a court-appointed attorney, sir?
I don't need a court-appointed attorney.
I'm sorry, I didn't hear it.
I don't need a court-appointed attorney.
Are you certain? I only would have to ask you 2 questions to see if you qualify.
Yes, I'm okay, ma'am.
I'm sorry, I didn't hear you.
I'm okay.
Okay. So, do you currently have a job?
Yes, ma'am. All right.
You do? Okay, how much do you make a month?
About 900 a month.
900?
Yeah.
Okay. Well, you would qualify for a court-appointed attorney, so if you need one, it will be in place for you, okay?
Okay.
Okay, thank you.
All right, who's the next one on your list, Your Honor?
The first one, we're going to alphabetical order. I have, is it Anderson, Allen, or Anderson?
Mr. Anderson.
Okay, state your full name for me, sir.
John Anderson.
Okay, Mr. Anderson, you've been charged with 3 offenses. The first offense is rape. The second offense is aggravated sodomy. And the third offense is incest. Because of the nature of the charges, I'm not authorized to set bond for you today. Therefore, there's a no bond. Do you understand the charges as well as the no bond?
Yes, ma'am.
Secondly, I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. And then your bond hearing will be December 2nd, 2022 at 8:30 a.m. You understand those two different hearing dates?
Yes, ma'am.
Also, it looks like you also refused to complete your court-appointed counsel form. Do you mind if I ask you a few questions to see if you qualify?
No, ma'am, I will have an attorney already.
Okay, you say you already have your own attorney?
Yes, ma'am.
Okay, are you certain?
Yes, ma'am.
Okay. Well, that will conclude your first appearance hearings for this morning. Thank you.
Thank you.
So you go that way to the other door and then don't let the door slam.
Your Honor, what's the next one you have?
Yeah, I don't have a list, Alan.
Alan? No, Your Honor, one of the deputies have. Your Honor, he's a fugitive. Do you want to do him last?
Yes.
Oh, you can take a seat.
Alan is a fugitive. Yes, I'll do him last. Okay, next one I have is Brookin, Brookin. Do you have him?
Yes, Your Honor, he's right here.
Okay, sir. You've been charged with, good morning. You've been charged with 4 offenses. The first offense is violation of Georgia Controlled Substance Act. Your bond amount is $5,000. The second charge is possession of a firearm during a crime. Your bond amount is $10,000. The third offense is giving a false name, address, or date of birth to a law enforcement officer. Your bond amount is $1,000. And then the fourth charge is possession of a firearm by a convicted felon. Your bond amount is $10,000. Therefore, your total bond amount is $26,000. Do you understand the charges as well as your bond amount?
Yes, ma'am.
Okay, and can you make bond?
Yes, ma'am. I have someone up here right now.
Okay. Secondly, I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. You understand that's your next hearing date?
Yes, ma'am.
And based on your application, you would qualify for a court-appointed attorney. So I will approve your application. Do you have any questions?
When I would talk to the attorney.
Once I conclude the first appearance calendar in the morning, I normally send over your court-appointed form. So they'll be in contact with you shortly. I'm not certain of the time frame, but once I usually send over the form the same day.
Yes,
after the
ma'am.
first appearance calendar.
And you said I have a bond, so can I pay everything today?
I'm not involved in the arrangements of your bond. That's something you would have to speak to the sheriff's office about. But I have set the bond, okay? And the
Thank
total
you.
is 26,000. Okay. Thank
Thank
you.
you.
You can go back. Just don't let the door slam.
Okay. Calhoun,
He's coming up, Your Honor.
good morning, sir. You've been charged with 2 offenses. The first offense is aggravated stalking. The second offense is terroristic threats. Because of the nature of the charges, I'm not authorized to set bond for you today. Do you understand the charges as well as the no bond, sir?
Yes, ma'am, I do.
Secondly, I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. And then your bond hearing is scheduled for December 2nd, 2022 at 8:30 a.m. You understand those 2 different hearing dates? You understand the 2 different dates, sir?
Yes, ma'am, I do.
Okay. And you would qualify for a quarter, I'm assuming, well, you didn't answer the question. Do you have a job?
No, ma'am, I've been,
Okay. So you would qualify for a court-appointed attorney? Do you have any questions? Have any questions, sir?
no, ma'am, I do not. I'm sorry.
Okay, thank you.
Thank you. Go back.
Okay, the next inmate deputies?
His name, Your Honor, because I do not have the list. I think one of them took
Y'all
it.
making me work today, okay.
He took it off my table, ma'am. I'm sorry
Okay,
about that.
is Abraham Karoma?
I hear you, Your Honor.
Okay, sir, you've been charged with 2 offenses. The first offense is speeding. Your bond amount is $2,000. The third charge is driving without a license. The bond amount is $1,000. Therefore, your total bond amount is $3,000. Do you understand the charge as well as your bond amount? Yes, sir. I need a verbal yes, sir.
Yes,
Okay.
ma'am.
And I've scheduled your preliminary hearing for November the 29th, 2022 at 8:30 a.m. via Zoom.
Yes, ma'am.
Would you like to waive your preliminary hearing or keep it on the court's calendar?
Say that one more time for me.
You have because you've only been charged with a misdemeanor, you have the option of waiving your preliminary hearing or keep it on the calendar. If you're unsure if you're gonna make bond, I would recommend you leave it on the calendar, but it's up to you. Do you want to waive it or do you want to keep it on the court's calendar?
I'm be able to, make bond.
Okay, if you bond out, it'll be automatically waived. Is that what you want to do?
Yes, ma'am.
Okay. Then I also see that you completed your application for court-appointed counsel. You say you have a job, but you're unsure how much you make a month. Can you give me a range, an estimate?
Sometimes the hours, we be leaving early, so I could just say like from 1,500 or more.
Okay, 1,500.
Yes, ma'am. I'm finna get a job.
So based on your income, you would qualify for a court-appointed attorney. So I will appoint an attorney to represent you. Do you have any questions?
No, ma'am.
Okay, thank you. I have William Matthew Trail Senior, deputy.
I sent him the next 2 that we need.
Okay, thank you. Okay, sir, state your name for the record so I can make sure I have the right person. Okay, so you've been charged with 2 violations. Violation of Georgia Controlled Substance Act, and then the second offense is use or possession of drug-related items. Because you are currently on active probation, I'm not authorized to set bond for you today. Do you understand the charges as well as the no bond? You say yes?
Yes, ma'am.
Okay. I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. And then your bond hearing will be December 2nd, 2022 at 8:30 a.m. You understand those 2 different hearing dates?
Yes, ma'am.
Also, based on your application for court-appointed counsel, you would qualify for a court-appointed attorney, so I will approve the application. Do you have any questions?
No, ma'am.
Thank you, sir.
Daniels. Daniels. No. Yeah, Daniels. Davis. My fault, Davis. Yes.
Do you have the list, or I can send you some names in the chat, the next 3. Okay?
I have the list.
Okay.
Yes, I'm trying to see who the next person is, man.
It's Daniel Lee Davis.
Okay, yep, I got it right here.
Good morning.
Morning. Okay, so you've been charged with two offenses. The first offense is speeding. And the second offense is giving a false name, address, or date of birth to a law enforcement officer. Your bond amount for the speeding is $500. Your bond amount for giving the false name, address, or date of birth is $1,000. Therefore, your total bond is $1,500. Do you understand the charge as well as your bond amounts?
Yes, ma'am.
Can you make bond?
Yes, ma'am.
I've scheduled your preliminary hearing for November the 29th, 2022 at 8:30 a.m. You understand that's your next court date?
Yes, ma'am.
And it does, based on your income, you would not qualify for a court-appointed attorney. So you will have to hire your own attorney. You understand that?
That's fine.
Okay. Thank you, sir.
Thank you.
Gibson.
What about Francis? I already did. Oh, that's a fugitive.
He's a fugitive, Your Honor.
Okay, Gibson. State your full name for me.
Joshua Gibson.
Okay, Mr. Gibson, you've been charged with 4 offenses. The first offense is aggravated assault with a deadly weapon. The second offense is reckless conduct. The third offense is criminal damage in the second degree. And the fourth offense is discharge of a firearm near a highway. Because of the nature of your charges and the circumstances, sir, I'm denying you bond today. Do you understand the charges as well as the no bond? You say yes? Okay. I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. And then your bond hearing will be scheduled for December 2nd, 2022 at 8:30 a.m. You understand that?
Yes, ma'am.
And did you complete a request for court-appointed counsel? You recall completing the application, sir?
Yes.
Deputies, I don't see a court-appointed counsel form for Mr. Gibson.
Your Honor, there should be one for him.
I guess I have to locate. I just, let's see, I don't see it here.
Yeah, he should be number 13. I definitely, when I put the list together, was number 13. I seen
You
it.
said he was number 13?
Yes, ma'am, on that list. He should be 13.
For some reason, I don't have a 13. So let me ask you, sir, are you currently employed?
Yes, ma'am.
And what are your monthly wages?
Like 5 to 6K.
Okay, sir, based on that, you said 5 or 6,000? Okay, based on the response, you would not qualify for a court-appointed attorney, therefore you will have to hire your own attorney. You understand that? You understand that, sir? Okay, and so that will conclude your first appearance hearing. I'm gonna briefly go off the record because I need to find, I don't see the court-appointed form for him. I'm gonna go back to the email to see if it's in the file. But that will conclude your first appearance hearing for today. Thank you, sir. Give me 1 minute, deputies.
Yes, Your Honor.
Come back on the record, the next inmate. Is it Jordan? Okay, you're on mute, Jill.
It's Xavier Jordan, Your Honor.
Good morning, sir. You've been charged with 4 offenses. The first offense is improper lane change. Your bond amount is $500. The second offense is violation of Georgia Controlled Substance Act. The bond amount is $5,000. The third offense is possession of a firearm during a crime. The bond amount is $10,000. And the fourth offense is use or possession of a drug-related item. The bond amount is $1,500. Therefore, your total bond amount is $17,000. Do you understand the charges as well as your bond amounts?
Yes.
Can you make bond?
Yes.
Secondly, I've scheduled your preliminary hearing for November 28, 2022 at 8:30 a.m. via Zoom. You understand that's your next court date, sir?
Yes.
And you also, I have a form for you, but you did not complete the court-appointed counsel application. Do you not need an attorney, sir? Okay, would you mind if I ask you a few questions to see if you qualify?
I've already been attorney.
You already have hired your own attorney?
Yes, ma'am.
Okay. Do you have any questions?
No, ma'am.
Okay, thank you. Okay, state your full name for me.
No,
And that's Kimbrell, Kimbrell. That's correct, sir?
yes, ma'am.
So you've been charged with 3 offenses. The first offense is battery, family violence. Your bond amount is $5,000. The second offense is theft by taking. Your bond amount is $2,000. And the third offense is obstruction or hindering an emergency telephone call. Your bond amount is $1,500.
Okay.
Therefore, your total bond amount is $8,500. Do you understand the charges as well as your bond amounts?
Yes, ma'am.
Can you make bond?
Yes.
Okay, if you can make bond, there will be special conditions included on your bond order. The first condition is you're to have no contact with the alleged victim in the case, identified as Glenda Kimbrell. You recognize that name?
Yes, ma'am.
Okay, I believe that's your mom, correct?
Yes, ma'am.
So there's a no contact, which means you must stay away, absolutely, directly, indirectly, by mail, by email, by pager, by text message, by social media, by telephone. You cannot contact your mom through a third person. You cannot go to her home or workplace. Secondly, because the alleged incident occurred at 5713 Lee Street, Morrow, Georgia, 30260, you're not to return to that location while you're out on bond.
Yes, ma'am.
These are, you understand, is that location your primary residence, sir?
Yes.
Okay, so you will need to make arrangements to live elsewhere. However, I will allow you to make an appointment with the sheriff's office within 10 days of your release to retrieve any undisputed personal property from that location.
Okay.
You
Yes.
understand that?
Yes, ma'am.
Secondly, your preliminary hearing scheduled for November the 29th, 2022 at 8:30 a.m. via Zoom. You understand that's your next court date, sir?
Yes, ma'am.
Now, you also refuse to complete your court-appointed counsel application. Do you not need an attorney?
No. No, ma'am.
Okay, you're gonna hire your own attorney?
No. All right. Yeah.
You are? Because I can see if you qualify, so you can have one in place just in case.
I'll get a court appointed one if I. Yeah.
Okay, so do you have a job?
No, no.
Okay, you would qualify for a court-appointed attorney. So I will appoint an attorney to represent you. Do you have any questions?
No.
Thank you.
Thank you.
All right, so just go back to your house, sir. Your Honor, next person is Mr. Martin.
Okay. Okay, Mr. Martin, give me your full name. Your full name, sir?
Martin.
Mr. Martin, you've been charged with 2 offenses. The first offense is battery, multiple times against the same victim. And the second offense is theft by taking. Theft by taking. Because of the nature of the charges and the circumstances, I am not granting bond for you today. Do you understand the charges as well as the no bond?
Yeah, I understand the charge. I need to talk to somebody about it, of course.
Okay, but do you understand the no bond? I'm not granting bond for you today because of the circumstance. It appears like it's been the same victim 3 times. You understand that? And I'm concerned about the victim's safety. You understand that?
Okay, the victim.
But we're not here to try your case today. I'm gonna do a no bond. However, I've scheduled your next hearing for November the 28th, 2022 at 8:30 a.m. You understand that?
November
And your
22.
bond hearing will be December 2nd, 2022 at 8:30 a.m. You understand those 2 different hearing dates? You understand the 2 different hearing dates, sir?
Say December.
The first one is November the 28th, 2022 at 8:30 a.m. That's your preliminary hearing. So the purpose of the preliminary hearing is to determine there's sufficient evidence to continue to detain you. And then the second will be your bond hearing. Okay, and that's to determine if you will be granted bond. You understand that?
That's December.
December 2nd. You understand that?
Yeah. Yes, ma'am.
Okay. And based on your application, you would qualify for a court-appointed attorney, so I will appoint an attorney to represent you. Do you have any questions? Okay, thank you.
Next one is, Your Honor, McAllen. How you say it?
Okay, state your full name for me.
Hi, Andrew McClellan.
Okay, middle name is Carr.
Yeah,
So you've been charged with 6 offenses. The first offense is burglary. Your bond amount is $25,000. The second offense is possession of tools during the commission of a crime. The bond amount is $2,000. The third offense is open container in violation of Georgia law. The bond amount is $500. The fourth offense, the fourth offense here is parking, prohibited parking. Bond amount is $500. And then you have 2 separate counts of contributing to the delinquency of a minor, and the bond amount for each charge is $4,000. So therefore, your total bond amount is $36,000. Do you understand the charges as well as your bond amount?
yes, ma'am.
Can you make bond?
No, ma'am.
Secondly, I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. You understand that's your next court date, sir?
Yes.
And based on your application, you would qualify for a court-appointed attorney, so I will appoint an attorney to represent you. Do you have any questions? Thank you.
Next one, Your Honor, is Murray, Antonio Murray.
Okay, thank you. Okay, Mr. Murray, you've been charged with 1 offense of lottery. Your bond amount is $1,000. Do you understand the charge as well as your bond amount?
Yes, ma'am.
Can you make bond?
Yes, ma'am.
If you can make bond, there will be special conditions included on your bond order. The first condition is you're not to return to the incident location identified as 8023 Autumn Forest Drive, Jonesboro, Georgia 30236. You understand the special conditions on your bond order, sir?
Yes, ma'am.
Secondly, I've scheduled your preliminary hearing for November the 29th, 2022 at 8:30 a.m. And then based on your court-appointed application, you put that you're employed, but you didn't put your monthly wages. Can you give me an estimate?
Ma'am, I just started working this week.
Okay. How much you get paid an hour?
8.
$8?
Yes, ma'am.
Okay. So you will qualify for a court-appointed attorney, sir. So I will approve your application. You have any questions?
Tell me what date I gotta go to court again?
It's November the 29th, 2022, but if you bond out, that preliminary hearing will automatically be waived. Do you want to waive it or you want to keep it on the calendar?
It'd be best to wait.
No, it's up to you. If you're gonna, we can leave it on the calendar, and then if you bond out, it's automatically waived. You understand that? Do you understand that, sir? If you bond out, your preliminary hearing will be waived. It's no reason to have the hearing if you're already out on bond. You understand that?
Yes, ma'am.
Okay, thank you.
There is Price.
Okay, sir, you've been charged with 1 count of simple battery, family violence. Your bond amount is $5,000. Do you understand the charges as well as your bond amount? Is that a yes, sir?
Yes, ma'am. I understand.
Can you make bond?
Yes, ma'am.
Okay, if you can make bond, there will be special conditions included on your bond order. The first condition is you're to have no contact with the alleged victim in the case, identified as Jamie Ursher. Do you recognize that name?
Yes, ma'am.
You must stay away, absolutely, directly, indirectly, by mail, by email, by pager, by social media, by text message, by telephone. You cannot contact her through a third person. You cannot go to her home or workplace. You understand that? You understand that, sir? Yes or no?
Yes, ma'am.
Also, because this is a family violence incident, do you live with the alleged victim?
Yes, ma'am. Yes, I do.
Okay. Do y'all currently live together at this 3110 Mount Zion Road location?
No, ma'am. We live at 6996 Fielder Road.
Okay, yeah, so that's the incident location I have.
Yes,
So
ma'am.
because the incident occurred at 6996 Fielder Road, Rex, Georgia 30273, you're not to return to that location while you're out on bond. Is that your primary residence?
Yes, ma'am, it is.
Okay, well, you'll need to make arrangements to stay elsewhere. However, I will include a provision in the order that will allow you to make an appointment with the sheriff's office within 10 days of your release to retrieve any undisputed personal property at that location. You understand that?
Yes, ma'am.
Okay, I'll schedule your preliminary hearing for November the 29th, 2022 at 8:30 a.m. You understand that's your next court date, sir? And you did complete a request for court-appointed counsel. Based on the application, you will qualify for a court-appointed attorney. So I will approve your application. Do you have any questions?
No, ma'am, I know.
Thank you.
Your Honor, the next we got is Plumber.
Okay,
Morning.
good morning, sir. How are you doing?
Fine.
You've been charged with 2 offenses. The first offense is theft by receiving stolen property. Your bond amount is $2,000. The second charge is possession of a firearm by a felon. The bond amount is $10,000. Therefore, your total bond amount is $12,000. Do you understand the charges as well as your bond amount? Can you make bond?
Yes, ma'am.
Secondly, I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. You understand that's your next court date, sir?
Yes, ma'am.
Now, you do have a form where it appears you did not complete your court-appointed counsel form. Do you not need an attorney?
I got one already.
You got your own?
Yes, ma'am.
Okay. You have any questions?
No, ma'am.
Thank you, sir.
Thank you.
Your Honor, the next one is Mr. Smith.
Yeah, Mr. Smith. Nicholas,
Yes,
first
ma'am.
name? Okay.
Yes, ma'am. How you doing, ma'am?
Good, how are you today, sir?
How good in that position?
You've been charged with 2 offenses. The first offense is possession of a firearm by a felon. Your bond amount is $10,000. The second offense is possession of marijuana less than an ounce. Your bond amount is $1,500. Therefore, your total bond amount is $11,500. Do you understand the charges as well as your bond amount?
Yes, ma'am.
Can you make bond?
Definitely.
Definitely great. I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. That's your next court date, sir. You understand that? You understand that's your next court date?
Yes, ma'am.
Okay. And based on your court-appointed application, you would qualify for a court-appointed attorney. So I will appoint an attorney to represent you. Do you have any questions?
No, ma'am.
Okay, thank you, sir.
No, one time. Okay. You said 11,000, right?
Yes, it's 11,500, 10,000 for the possession of a firearm, and then 1,500 for the possession of marijuana, less than an ounce.
Thank you.
Stargell. Correct me if I'm right. Stargell, Your Honor.
I got it. Thank you.
Your Honor.
Good morning, sir. How are you doing?
Well, thank you.
You've been charged with 6 charges. Each charge is a charge of criminal trespass, and the bond amount for each criminal trespass charge is $1,500. Therefore, you have a total bond amount of $9,000. I'm sorry, let me clarify. You have 3 charges of criminal trespass, and then you have 3 charges for criminal attempt. You understand that?
Yes, Your Honor.
See. And let me briefly go off the record to make sure that the warrant is correct. Give me a minute.
Yes, ma'am.
Let me clarify, sir. So you have 3 separate criminal trespass charges. And so for the first criminal trespass charge, your bond amount is $1,500. For the second criminal trespass charge, your bond amount is $1,500. For the third criminal trespass charge, your bond amount is $1,500. Then you also have 3 criminal attempt charges. The bond amount for the first criminal attempt charge is $3,000. The second criminal attempt charge, the bond amount is $3,000. And then the 6th charge of criminal attempt is $3,000. Therefore, your total bond amount is $13,500. Do you understand the charge as well as your bond amounts?
Yes, Your Honor.
Okay, can you make bond? You can make bond, sir?
Yes, ma'am, Your Honor.
I've scheduled your preliminary hearing for, let me just make sure here. Your preliminary hearing is going to be November the 29th, 2022 at 8:30 a.m. because they're all considered misdemeanors. Would you like to waive your preliminary hearing or keep it on the court's calendar?
You can remain on the court's calendar and disappear once I make bail, Your Honor.
Great. And you did complete a request for court-appointed attorney. Based
Yes,
on
Your
your application, you would qualify for, you say you make about $300 a month?
Yes, ma'am. It's part-time work, Your Honor.
Okay. And you only have a part-time job?
That's correct, Your Honor.
Okay. So you would qualify for a court-appointed attorney? So I will approve the application. Do you have any questions?
No, Your Honor.
Thank you.
Thank you, Your Honor. Justin Tiller.
Your Honor,
Yes, sir.
Justin Tiller's coming back. He just had to go to the bathroom. Your Honor.
Okay.
Mr. Tiller, come on, sir. Come on. All right, Mr. Tiller coming up.
Okay, so you've been charged with two charges. The first charge is simple battery, and then the second charge is battery. Your bond amount for the simple battery is $4,000. Your bond amount for the battery charge is $6,000. Therefore, your total bond amount is $10,000. Do you understand the charge as well as your bond amount? Okay, can you make bond?
Anybody get no OR bond on those?
You say you're unsure?
Say, is there any way I can get an OR bond on those?
No, sir, I'm not authorized to grant OR bond. Only the chief judge can do that. So your bond amount again is $10,000, $4,000 for the simple battery, $6,000 for the battery. Secondly, if you can make bond, there will be special conditions included on the bond order. The first condition is you're to have no contact with the alleged victims in the case, specifically Kevin Tiller, which I believe that's your brother, correct?
Mm-hmm.
And then your father, is it Joe Tiller? Is that correct?
Mm-hmm.
Because they're the alleged victim in the case, there's a no contact, which means you must stay away, absolutely, directly, indirectly, by mail, by email, by pager, by text message, by social media. You cannot contact them by telephone or through a third person. You cannot go to their home or workplace. You understand that?
Understood.
Secondly, because the alleged incident occurred at 9061 Homewood Drive, Riverdale, Georgia, 30295, you're not to return to that location while you're out on bond. You understand that?
Understood.
I've scheduled your preliminary hearing for November the 29th, 2022 at 8:30 a.m. You understand that's your next court date, sir?
What's now, September?
No, November 29th, November.
Yes, ma'am, understood.
And
What's the
then
date?
I'm sorry, what was your next question? Your next question, sir?
What's the day's date?
Today is November the 11th.
Thanks so very much, ma'am.
Also, you look like you started completing your court-appointed application, but you did not complete the questions that ask if you have a job. Do you currently have a job, sir?
I'm with a traumatic brain injury at this point, and also a traumatic spinal cord injury.
Okay, so you're currently unemployed?
Yes, ma'am.
Okay. So based on your response, you would qualify for a court-appointed attorney, so I will appoint an attorney to represent you. Do you have any questions?
No, ma'am.
Okay, thank you.
Just go ahead and take a seat. Take a seat. Your Honor, the next one I have is Mr. Turner.
Okay, thank you.
Good morning, Your Honor.
Good morning, Mr. Turner. You've been charged with 3 offenses. The first offense is possession of marijuana less than an ounce. Your bond amount is $1,500. The second offense is no tail lights. The bond amount is $500. And then the third offense is use or possession of drug-related items. The bond amount is $1,500. Therefore, your total bond amount is $3,500. Do you understand the charges as well as your bond amounts?
Yes, ma'am.
Can you make bond?
Yes.
Yes. I've scheduled your preliminary hearing for November the 29th, 2022 at 8:30 a.m. Would you like to waive your preliminary hearing or keep it on the calendar?
Keep it on the calendar.
Okay. Lastly, it does appear you qualify for a court-appointed attorney. So I will approve your application. Do you have any questions?
No, ma'am, I don't.
Thank you.
All right, thank you.
Next one I got is Vaughn.
Okay. Mr. Vaughn, you've been charged with 3 offenses. The first offense is possession of marijuana less than an ounce. The bond amount is $1,500. The second offense is distracted driving violation. The bond amount is $1,500. And then the third offense is impeding traffic. The bond amount is $500. Therefore, your bond amount is $3,500. Do you understand the charge as well as your bond amount?
Yes, ma'am.
Can you make bond?
Yes, ma'am.
Okay. I schedule a preliminary hearing for November the 29th, 2022 at 8:30 a.m. You understand that's your next court date, sir?
Yes, ma'am.
Would you like to waive your preliminary hearing or keep it on the court's calendar?
You keep it on the court calendar.
Okay. And based on your application, you do not qualify for a court-appointed attorney, therefore you will have to hire your own attorney. You understand that?
All right.
You understand that, sir?
I understand.
Okay, any questions? Okay, sir, thank you.
Next one, Your Honor, is Weaver.
Okay, Mr. Weaver, you've been charged with two offenses. The first offense is interference with custody. Your bond amount is $4,000. The second offense is obstruction of a law enforcement officer. Your bond amount is $1,000. Therefore, your total bond amount is $5,000. Do you understand the charges as well as your bond amount? Do you understand the charges, sir?
No, ma'am, with the interference part, them my grandkids.
I understand, but it states here in the warrant is that you committed the offense of interference with custody when you failed to release Danielle Kitchens, two juvenile kids back into her custody. Is that your daughter?
Yes, ma'am. But with that situation is we was trying to get the officer the court documents, and then they jumped on us in the house.
Okay, well, again, I'm not here to try your case today. My only purpose is to set bond for you and then to appoint an attorney if you need one. You understand that? You understand that, sir?
Yes, ma'am. How much was it?
The total bond is $5,000, $4,000 for the interference with custody. And the second charge, obstruction of a law enforcement officer, is $1,000. Okay. Also,
How much the total?
I've scheduled your preliminary hearing for November the 29th, 2022 at 8:30 a.m. You understand that's your next court date?
Yes. How much was the total again?
$5,000, $5,000. Okay, you understand that? Also, based on your application, you would qualify for a court-appointed attorney. So I will appoint an attorney to represent you. That will conclude your first appearance hearing. Thank you, sir.
Your Honor, we have one more before we do the two fugitive. His name is Luis Cruz Reyes.
Okay.
Mr. Reyes.
Okay, so you've been charged with one offense of sexual exploitation of children under OCGA 16-2-100B5. Based on the nature of the charges, I'm not setting bond for you today. Do you understand the charge as well as the no bond?
Yes, ma'am.
I've scheduled your preliminary hearing for November the 28th, 2022 at 8:30 a.m. And then your bond hearing will be December 2nd, 2022 at 8:30 a.m. You understand those two different hearing dates?
Yes, ma'am.
And then I know you we didn't have a separate form for you to fill out, but do you need a court-appointed attorney, sir?
Yes, I do.
Okay. Are you currently employed?
Yes, I am.
Okay, and what are your monthly wages? I'm sorry to hear you, sir. What are your monthly wages?
$1,200 a month.
You said 4,000?
1,000.
$1,200? Okay. So based on your response, you would qualify for a court-appointed attorney, so I will appoint an attorney to represent you. Do you have any questions? Okay. Thank you, sir.
Your Honor, the last two we have is Mr. Allen and Mr. Francis, the two fugitives.
Okay, if you could bring them forward, I'm gonna do their opening remarks at the same time.
There you go.
Let me just locate their paperwork here. So good morning, Mr. Allen and Mr. Francis. My name is Judge, good morning. My name is Judge Tamika West. I'm a magistrate court judge in Clayton County. I will be presiding over your extradition hearing for this morning. All the rights that I have advised everyone of early in my opening remarks also apply in your case, but your hearing is just a little bit different than the other first appearance hearings that is taking place today. First, you do not have charges pending against you here in Clayton County. You have been brought to court today because you have charges pending against you in another state. And they're requesting that you return to that state to answer to the charges. First, I'm going to ask you, Mr. Allen, are you in fact Michael Joseph Allen?
Yeah.
Okay. And then Mr. Francis, are you in fact Taryn D. Francis?
Tyron Dominic Francis, yes.
Okay, let me ask you, Mr. Allen, are you currently represented by an attorney in this matter?
No.
Okay, and then Mr. Francis, are you currently represented by an attorney in this matter?
No, ma'am.
Both you, Mr. Allen, as well as you, Mr. Francis, are charged with being a fugitive from justice. This hearing is being conducted pursuant to OCGA Title 17, Chapter 13. As you have heard, with respect to Mr. Allen, as you've heard, it is alleged that you are charged with a crime from the state of Louisiana. And the state of Louisiana is asking that you be returned to that state because you have an active warrant. And then with respect to you, Mr. Francis, it's the state of Florida that is requesting that you return to the state to answer to a charge of felony battery. So I'm going to ask you, Mr. Allen, do you recognize, were you aware that you had an outstanding warrant from the state of Louisiana?
I wasn't aware of it until I got arrested for it.
Okay. And then Mr. Francis, were you aware that there was an outstanding charge for you for felony battery?
Yes, ma'am. And I was released from prison with this whole, I went through this before where I signed my extradition and they haven't came and
They
got
come and get you? Was it in the state of Georgia?
of Alabama.
Okay.
And
So
it was in the state of Georgia as well, ma'am. In the state of Georgia, it was actually.
Okay.
It didn't come get me, and it happened in Alabama too. And when I was released from prison.
Okay. So again, because you are what they consider to be a fugitive from justice, then they do have a right to demand your return back to their state. You understand that?
Yes, ma'am.
Okay. Now you have a choice as to whether or not you wish to contest the extradition or waive the extradition and be returned to the other state without going through the formal extradition process. That's the right above you, Mr. Allen, as well as you, Mr. Francis. If you decide that you wish to contest the extradition, the court may commit you to the county jail for an initial period of 30 days. During that time, a warrant will be prepared under the governor's signature for your extradition to the other state. The court may consider allowing you to post bond, but the court is not required to post bond for you, to allow you bond in your case. As you're wanted by another jurisdiction, Mr. Allen, I'm not setting bond for you in your case at this time, and Mr. Francis, I'm not setting bond for you at this time. If you do not wish to return to the demanding state, you may file a writ of habeas corpus to contest the extradition, but you can only contest the extradition on 4 grounds. The first is whether or not the extradition documents are in order on their face. Secondly is whether you're charged with a crime that actually exists in a demanding state. So with respect to you, Mr. Allen, that will be the state of Louisiana. With respect to you, Mr. Francis, that will be the state of Florida. Thirdly, you can contest on whether or not you are in fact the person named in the request for extradition. And the fourth ground is whether you are in fact a fugitive from justice. You cannot contest the issue of your guilt or innocence in the state of Georgia. You are entitled to the advice of counsel in contesting extradition or in deciding whether to waive extradition. If the state, that means the demanding state, is unable to extradite you within 30 days, you will be committed to the county jail for an additional 60 days while awaiting your extradition. If the extradition is not completed in 90 days, then you'll be released. That's if you contest. Now, if you voluntarily decide to waive extradition and return to the demanding state that is asking for your return, in your case, Mr. Allen, that will be the state of Louisiana. In your case, Mr. Francis, that will be the state of Florida. They will have up to 60 days to travel here to transport you back to the demanding state. If they do not come to transport you back, then you will be released. Do you have any questions regarding your rights as I've explained them to you today? First, I'll ask you, Mr. Allen, do you have any questions?
Yes, it's 60 days for Louisiana.
Yes.
I was told it was 15 days, but
No, it's not.
all right.
Okay, so the difference is if you contest, then they have up to 90 days. If you waive, they have up to 60 days. You understand that? So what would you like to do? Would you like to waive extradition or contest it? I need to hear verbal. Okay, so you will have to sign 6 forms from the deputy waiving, and then once you sign, then I'll sign executing the waiver documents. You understand that?
Yes, and once you sign, that's when the extradition starts.
Yes. Okay, that's when the clock will start. Okay. Okay, and then Mr. Francis, I know you've been through this process before. Do you have any questions about your rights?
Yes, before, and I just don't understand how it's gonna take 60 days. They never come get me in my case, ma'am, so I would be doing 60 days for no reason. Once again.
Well, you have the option. Well, first I would say this, I can't offer you legal advice, but you always have the option of returning to the state to see if you can resolve it. Like say, for instance, in this case, if they don't come and get you, you always have the option of returning to the state to see if you can resolve it. Okay, but the only option at this point is to waive the extradition or contest it. You can contest it if you like. You don't have to waive extradition. You can contest it. It's up to you.
Hey, man, but look, it's one thing, and I know I've gotten my case is closed down there. Who do I give that to up here for them to see that?
Well, your attorney, do you have an attorney representing you in that previous case on the felony battery? Do you have an attorney representing you in that case, sir? I didn't hear you. I can't hear you, sir. So Deputy, okay, you were going out. So do you have an attorney representing you in the felony battery case?
Yes, ma'am.
Okay, well, I would recommend you contact your attorney on the felony battery in Florida. Okay, but the only choices that we have here is either you can contest extradition or you can waive it today. It's up to you, but I need a response.
My extradition, ma'am.
I'm sorry, I didn't hear the response.
I am going to waive my extradition.
Okay, well, if you would like to waive it, then you will need to sign the waiver forms from the deputies, and then once you sign it, then they will send to me for me to execute, and then I will return them to the jail to be processed. You understand that?
Yes, ma'am.
Okay, well, thank you so much, Mr. Francis, and good luck. Okay, that will. Do you have one? I'll allow one more question. You have one more question?
Yes, the waiver of this gets sent to the Florida, right?
Yes, my understanding is.
Okay.
Okay, thank you. Thank you, Mr. Allen. Thank you, Mr. Francis.
Thank you.
That's all we have, Your Honor.
Okay, thank you so much. So if you can get those waivers sent over to me and then by 1, that would be great. Deputies, can you do that?
They'll be on the way.
Okay.
You have a good weekend.